Hello, everybody, and welcome back to the Jurisprudence podcast with me, Alex.
And me, Charlotte.
And today we're going to be talking about an issue that is a very politically charged issue, at the very least, and is an issue that has been going and raging for very many years,
Yeah.
but that has actually come to the fore when we talk about its political impact in the United Kingdom. And this is the UK assisted dying bill. And the question of assisted dying, the question of its legality, the question of its ethicality, and all the different things associated with it.
Yeah, this is sort of waxed and waned over the years with multiple iterations of bills and legislation being proposed and then sort of set aside, and none of them have been very successful thus far. I think it was actually only a few years ago that they tried this before.
Yes, I think so, yeah.
So that failed, obviously, and now a private member's bill has been proposed with the new Labour government, and there's also one going through the House of Lords as well.
Yeah, there's one going through the House of Lords. No one's really speaking about the House of Lords one. I guess that's because where power and authority lies is in the Commons, of course.
Yeah.
But the bill itself, essentially what we're going to do is we'll talk about the bill itself, we'll talk about the basic elements of the bill, essentially how it works, not necessarily going into the deep intricacies, because I mean it's only a bill in its second reading, so that's likely and subjected to change if it does even get past the second reading. And then we'll just talk about some of the implications. One of the things that we've sort of been trying to research and trying to get an answer to is the human rights implications, namely the implications under the European Convention on Human Rights.
Yeah, I think it's also really important to untangle the human rights arguments, considering states' obligations to the ECHR, for example, and the moral implications and the ethical quandaries around this topic. Because I feel like a lot of people, I mean, we'll get into it a bit more later, but a lot of people correlate the two when actually human rights instruments are meant to encompass these moral ideas around what a person, their fundamental rights should be, etc., but also within the pragmatic application of the law, what states are able to institute in terms of legislation to protect people, taking into account other considerations as well. Just because you think that something is wrong doesn't necessarily mean that it's a rights violation.
Yeah, exactly. That's true. So the bill itself, its short title is the Terminally Ill End of Life Bill, or Terminally Ill Adults End of Life Bill, should I say specifically.
Yes.
Its long title is A Bill to Allow Adults Who Are Terminally Ill, Subject to Safeguards and Protections, to request and be provided with assistance to end their own life and for connected purposes. The sponsor of the bill is Kim Leadbeater, a Labour MP, and it is currently in its second reading, as I've just mentioned. I believe the vote on the second reading is on the 29th of this month, 29th of November. So essentially, the prevalence, relevance of this particular podcast episode might be reduced quite significantly by the end of this month, if this bill gets voted down, because, of course, the first reading is just a very basic preliminary stage. The second reading is where more debate happens, and then if it even gets past the second reading, it goes to the committee stage, and then the report stage, and then a third reading, then the House of Lords, etc., etc.
Yeah, for those not familiar with the English legal system, the first reading is basically where it's proposed. They do the title, and then they say, do we want to consider this bill for further debate and consideration? The second reading is when what we have at the minute is a draft bill. They've drafted up what the legislation might look like, and then they debate on some of the particulars of that and whether they want to go further into refining and honing the different aspects of the law.
Yeah, the technical aspects of the law is dealt with at the committee stage.
Yeah, and the committee stage brings in experts and consultation and that kind of thing to consider how to set the limits and make it work
Yeah.
as a piece of legislation.
The only thing that's really important about the first reading is probably the declaration that it is compatible with the Human Rights Act, which is required for any piece of legislation that is going through. They have to say, this is the bill, this is what it says. Also, it doesn't violate the HRA.
Yes.
Which is an interesting point. So essentially how it works is it is providing a system for which individuals on the NHS can get assistance in being able to allow themselves to die. I'm not going to say take their own life, because there's obviously a lot of political and moral charging in that kind of regard, in the same way that a lot of people who are very much supportive of assisted dying and are part of advocacy groups that support assisted dying don't like to use the words suicide or assisted suicide, which is of course what the legislation currently refers to. The Suicide Act Section 2 refers to assisted suicide, and so obviously that's just a sort of technical, moral, language-based distinction, but it essentially requires a person to be terminally ill. Terminal illness is defined as for inevitably progressive illness, disease, or medical condition which cannot be reversed by treatment, and the person's death is a consequence of that illness. So the bill as it stands at the moment limits the extent of terminal illness to that of people who could be reasonably be expected to have died as a result of their illness within 6 months. So
basically, you have a prognosis of in the next 6 months you are likely to die.
Yeah, you're likely to be dead within the next 6 months.
And there's no current treatment available to you to reverse that or address that.
So terminal illness is of course an illness that cannot be reversed, essentially. But there are obviously different kinds of terminal illness. Some of them can last 10 years, some of them can last 5 years, some of them can last 1 year. They're talking about a specific kind, the ones that can be reasonably expected to be dead within 6 months.
It's interesting as well that they make the distinction of a progressive illness as well. It's going to progressively worsen until you pass away.
Yeah, presumably as well. A person who is terminally ill, then, who is in that definition, has to have the capacity to make that decision, to make their own, to take their own life. This is obviously one of the politically charged issues. They have to be aged 18 or over at the time that the person makes the declaration. They have to be a resident in England and Wales for at least 12 months. They have to be registered as a patient with a general medical practice in England and Wales, and they may, on request, be provided with assistance to end their life in accordance with sections 5 to 22, which we'll get to in a second. The capacity question is sort of not examined in any great detail, because the capacity question just refers to the Mental Capacity Act of 2005. So the idea of capacity is just the same as the idea of capacity as cited by that legislation.
And that basically covers reasonable understanding of consequences and things of that nature.
Yeah, exactly. Now, I'm not going to go through every single part of this legislation, but essentially, in order to get this option, you have to have 2 doctors' assessments. Those 2 doctors cannot be, I believe, knowledge. They can't know each other, or they can't have knowledge of what the other person said. They have to be 2 separate doctors. I think they have to be separated, their consultations, in terms of a week. So there has to be one assessment and then a second assessment a week later. There will also be the requirement, I believe, for a High Court judge. There has to be a court approval where a person has made the first declaration under Section 5, which has not been cancelled. This person may apply to the High Court for a declaration that that the requirements of this act have been met in part of this declaration. So essentially, the point of this is that you have 2 doctors. They are 2 separate doctors. They're not sort of coordinated with each other. They both see you individually. You have an assessment. That assessment, I believe, has to be a week apart, and then you have to get court approval from a High Court judge to have this go through. And then I believe after that there has to be a cooling off period, which is essentially a 2-week period by which nothing can happen in that 2 weeks until you are able to be prescribed the medication, which will then lead to you taking your life. That's essentially the way in which it is structured, and there are a few issues that we can think of in relation to this piece of legislation. So there's the human rights implications. There's Article 2 of the ECHR. There's
Right to life.
There's Article 8 of the ECHR.
Private life.
Yeah, right to private and family life. And then there's Article 14 of the ECHR.
Discrimination.
Which is discrimination. I'm just going to let you to...
Yeah.
Should we do some more? What's Article 3?
Prohibition against torture.
Yes, okay. So
a little test for me.
Yeah, exactly. We'll just do all of them. Is that where you want to go first? You want to go looking at the human rights, or is there any other points you want to make?
Well, yeah, I think that the human rights arguments are quite interesting. Although, as you pointed out, with the bill even being discussed, it has to be in accordance with the Human Rights Act, which is by association in accordance with the ECHR. Because even though we've left the EU, we basically ratified all of the human rights instruments into our legislation.
Well, the EU is separate to the ECHR. They're completely different institutions.
Yes, I know that.
Yeah, the Council of Europe it doesn't matter. Brexit had no impact on the ECHR, but that's true, and that is a sort of procedural element that is required by the Human Rights Act, but that doesn't necessarily stop Parliament from passing a piece of legislation that
violates human rights.
That can violate human rights, because that's where obviously you have Section 3 of the Human Rights Act, which allows for the courts to interpret legislation in a way which is in accordance with the principles of the Convention rights, even stretching to quite significant degrees and quite significant lengths the language of the legislation. And then you obviously have Section 4, which allows for a judge to issue a declaration of incompatibility, to declare that this legislation is incompatible with the Human Rights Act.
Which doesn't necessarily mean that it will be repealed or stopped.
No, it's still... The declaration of incompatibility does not violate any basic principle of parliamentary sovereignty, but it obviously strikes at the heart of the distinction between legal sovereignty and political sovereignty. It would be not very politically advantageous for Parliament to just say, well, we don't care about this. We're going to carry on with the contradiction in place. So for the most part, I'm pretty sure in almost all circumstances where declarations of incompatibility have been issued, Parliament has amended the law. And I think I was going to say that you doing stuff about terrorism,
yes,
you will probably be very familiar with the fact that Parliament does often amend the law, but they do so in a way that doesn't really solve the problem. Things like what are they called? Not protection orders, where they have alleged terrorist suspects be taken away.
Terrorism prevention investigation measures.
Yeah,
TPIMs.
Yeah, things like that, and they sort of like, during the sort of early 2000s when the Terrorism Act was passed and all this kind of stuff, there were like back and forth with the House of Lords and the Supreme Court about what is and what isn't compatible with the Human Rights Act.
Yeah, they sort of end up tweaking the knobs, so to speak, so that it appears to be appropriate or it fits, but it still functions very much the same.
Yeah.
And then also we might point out, because you pointed out a couple of times, the prisoner voting rights.
Yeah,
is just a violation.
Yeah, that went I think that went all the way to the European Court itself, where prisoners, as part of the ECHR, prisoners have a right to vote in elections, but the UK has rejected that particular argument or that line of argumentation.
Yeah.
Let's get into the human rights then. So Rajiv Shah, who was, I believe, a advisor to a number of Lord Chancellors and Prime Ministers, wrote an article on the Human Rights blog talking about how an assisted suicide policy, or assisted dying policy, I'm using my language and not his now, would be in breach of the ECHR. At least one that was provided for on the NHS, as an organ of the state on the NHS, would be in violation of the ECHR. He makes a very simple argument, essentially. He argues that Article 2 of the European Convention provides for the right to life. Within that, there are positive obligations. There's a state's duty to protect life. There are also negative obligations. The negative obligation is to essentially not to not allow someone to prevent people from dying. Essentially, that makes sense.
Is it that the positive obligations require the state to institute legislation to protect people's like infringement on people's lives?
Yeah.
And then the negative obligation is that the state is not
Intentionally depriving someone of their life. Yeah,
the state must not do, and this goes to capital punishment. That was an exception under Article 2, and that was removed when capital punishment was sort of abolished in Europe.
Yeah, exactly. So there are exceptions to this negative obligation. The exceptions of self-defense, effecting a lawful arrest, quelling a riot, acts of war, and then there used to be the death penalty, but the death penalty was firstly taken away in terms of civilian situations, so a civilian death penalty, and then it was also removed as part of within the conduct of military operations as well.
Right. Yeah.
So sort of done in two steps. So that is essentially his argument. His argument is very simple. He says, quote, this negative obligation, the obligation to not intentionally deprive anybody of their life, prohibits the state from conducting euthanasia and assisted suicide itself, even as part of a well-regulated scheme with appropriate safeguards. That is what he says in relation to this. Now, have you got anything to say?
Well, I would say first off the bat that I think that's just not true.
Okay.
They goes on to say that although it's not really been tested in the court, this negative obligation in this circumstance
in relation to assisted dying.
I think if you read the current jurisprudence, specifically the one against Hungary and the one against Belgium.
Yes.
It's sort of implicit that the legislative regime that allows for assisted dying is sort of accepted. Now, we spent a little bit of time before the podcast trying to figure out whether assisted dying is provided in Belgium under the public health, because they have a public health system and also some private health.
Yeah, and that's important to reconcile, because his argument specifically is that a policy under the NHS as an arm of the state would violate the state's negative obligation to not intentionally deprive anybody of their life. In fact, the ECHR is basically neutral or silent on having a policy which allows private individuals to intentionally deprive life.
Well, they do say that wide discretion is conferred to states. They note that there's a growing trend of legislating for assisted dying structures. And there are also states that continue to criminalize and prosecute people that help people to go with
take
dignity.
Their own life. So this is one of the things. So there's a few things that we can note about the right to life. So firstly, the idea of assisted dying isn't protected by the ECHR. Some people try and make the argument that a right to life implies a right to death.
Yeah.
But that's not how the court has worded it. They argue themselves that a diametrically opposed right to death
does not exist.
And that would be stretching the living instrument doctrine of the ECHR a little bit too far. Yeah. Pretty much.
And that's not only under Article 2, but also under Article 8, because people have argued that it's undignified or it impedes on the privacy of their life, and also, the prosecution of their family members is also a violation of their Article 8 rights.
Yeah,
and they've rejected these as either inadmissible or said that there is no violation in these circumstances.
Yeah.
In fact, in 2002, there's a quite famous case, Pretty against UK, where I believe it was the woman who was seeking to go abroad, and I think it was to Switzerland,
Yeah.
to take her own life. And she made an application herself to the ECHR saying that it was a violation that her husband would be prosecuted if she went and did that, and that, you know, she would essentially be dying alone.
Yeah.
And they said that it was not a violation of any human rights for the state to decide to prosecute in that circumstance, because it is within that margin of appreciation, even back then, where it was less common.
Yeah, and that's a good point, and that hits on the margin of appreciation doctrine within the ECHR, where basically the ECHR, in a similar way to other regimes, in a similar way to other international treaties and courts and stuff, doesn't want to interfere unnecessarily with the sovereignty of democratically elected states.
Yeah.
And the basic idea of the margin of appreciation is that there are certain areas where it's probably better for states to legislate on that than for a judicially activist court to come down and hand down rulings and decisions on these particular issues. So, for example, in the same article, in Article 2, in terms of the right to life, the question of when life begins, as it pertains to things like abortion rights, for example, is not something that the ECHR is particularly interested in answering that question. I mean, that's a question that is sort of within the court's margin of appreciation, for states that are members of the Council of Europe to sort of deal with that question on their own. And there's not necessarily any reason, in my opinion, that this margin of appreciation doctrine couldn't be applied for when life ends.
Yes. Yeah, exactly. And I think it's really important to consider human rights instruments like this as a margin. They set essentially goalposts in which we have internationally or whatever accepted as appropriate, and the fundamental basic rights that humans need, and then states sort of operate within this sliver of legislative power.
Yeah, exactly. I think that an argument that can maybe be made is that the historically, when it comes to the application of the margin of appreciation doctrine, for the most part, it has applied quite liberally, shall we say, to positive obligations, but less so to negative obligations. So the state's obligation, the state's duty to protect life versus the obligation to not intentionally deprive someone of their life. You could maybe argue that there is not much room for the margin of appreciation here. But if that was the case, then surely that would have been spoken about or ruled upon in the myriad of cases that have been at the ECTHR, and that have been dealt with by in the case of Hungary, in the United Kingdom, in Belgium, for example. And like you said, the court has acknowledged the sort of growing number of legislative policies that will be implementing right to dying practices.
Yeah.
And has noted that and hasn't ruled in the negative in any way so far. And I guess the people who make the argument that this would violate the ECHR, the Assisted Dying Bill, have to really present the argument for why the United Kingdom system, or why this bill specifically, is different and unique, such that it will trigger a violation of the ECHR, where it hasn't in Belgium, or it hasn't in the Netherlands, it hasn't in Luxembourg, it hasn't in Hungary, and all these different things. So
I think that the idea, because the source of this argument is that the NHS operates as an arm of the state, and therefore the state is intentionally killing people.
Yes.
Essentially, that is the argument. And I really do feel like the emphasis on the positive act of having to administer something in order to assist someone to die before their prognosis is sort of being elevated or stretched unnecessarily, in my opinion. because if we look at the bill, it requires someone to make a request. They have to go out of their way, see 2 different doctors, and then go before a high court before it's able to be considered.
Exactly.
This isn't the state intentionally going forward and positively offering it to people. It's implementing a system where it's available to people if they request it. And I think that's an important distinction to make, because currently the situation is that people have to go abroad alone, because if any of their family members know about it, they will be prosecuted.
Or the threat of prosecution, at least.
At least at the threat of prosecution, because we also had a look, and only 4 cases since 2009 have been prosecuted.
Yeah, exactly.
And this was after the prosecution guidance was updated by our current Prime Minister. So that was quite a good development, in my opinion.
Yeah.
But interestingly, the system in Belgium, although is quite liberal, and we were quite shocked by that because it allows for quite a wide range of people to request this, they're allowed to be at home when they're administered drugs.
Yeah.
So I'm not really sure. To me, intuitively, it seems like it would fulfill the purpose that it's intended to fill.
Yeah, and this is obviously one of the arguments against this from a policy perspective. The idea here is that this is going to be a slippery slope.
Yeah.
The idea here is that when these policies were introduced in all of these different countries, in Canada, in Belgium, in Luxembourg, all these different places, they had very strict standards, very strict guidelines, similar to how this bill is worded and how this bill is structured. But then over time, they've widened the scope for people who are able to take their own lives, to the point where you have people who are under the age of 18, where you have minors that are able to take their own life, where you also have individuals who don't have necessarily any physical ailments, but they have mental conditions that are uncurable, being able to take their own life as well, which obviously raises quite significant philosophical and policy moral-based questions. Because
the argument is that there's no reason why we should treat mental health any differently. But I put a big question mark on that, because it does sit a little bit uneasily.
It doesn't sit great, does it?
I think that the point of treating mental health differently, we shouldn't treat mental health differently, is more on we should accept that it affects people in a similar way that physical health does, and it is equally as important. That doesn't necessarily mean that treatment can be conflated, if that makes sense.
But it would extend the scope of individuals who are able to die to those who are not terminally ill.
Yeah.
Because as far as I'm aware, as far as I know, terminal illness refers to physical illnesses. Is there such thing as a terminal mental illness? I don't think there is.
I mean, you can have a mental illness for the course of your life, but it waxes and wanes in terms of severity.
But the point of a terminal illness is that this is going to be the reason why you die in the future.
Yeah.
And within 6 months, according to this legislation. I don't think that is represented by mental health issues.
No.
But all of that is a hypothetical question, because that's not what this bill is doing.
No. And there shouldn't be a sort of slippery slope argument really in place, in the sense of, if we let this pass, then it's only gonna get worse, and we're gonna allow more people to seek this out, because those amendments will also need to be addressed. And the amount of time that has been spent the last 20 years going back and forth on this subject, I seriously doubt that would happen. Yeah,
and we can get into some of the arguments against it and see if we can think about any responses, or even the arguments for it, to see if we can think about any responses. The slippery slope argument is one that I was listening to a podcast earlier, and I heard someone make this point, that this, where will it end? Will it get to a point where if you're disabled in any way, you're able to just take your own life, and the NHS can give you a drug, and that's it, and you end up in a sort of eugenics kind of system? But the response to that from the person who was on that podcast said, well, things like speed limits haven't gradually gotten quicker and higher and higher and higher
Yeah.
just because they've been around for a long time.
Things like abortion.
Things like abortion rights as well, exactly. The idea that just because you set a standard, that standard is naturally or inevitably going to slip in a more liberal or a more progressive kind of way is not necessarily true. You can have very strong standards and very strong positions on these different kinds of policies. And the point that I made to you was, I don't know if this is true, but I'm pretty sure the age of consent in the UK, in England and Wales, was 18 at one point.
Yes.
And it's now dropped to 16.
Yes.
But we're not going to be seriously making the argument that it should go any lower, because that would be the same kind of slippery slope argument, and it hasn't. And so why should it? Why would we think it would?
It was actually 21 for homosexual activity.
Oh, really?
And then it was lowered to 18 and then to 16
Yeah.
after the fact.
Yeah, exactly.
So it's quite interesting. People point to this sort of slippage in limits being placed on legislation. The only reason why there is slippage is because we have a better understanding of the issue at hand. And it might be that this is more, morally acceptable, or we have a better understanding of the needs of this piece of legislation, and therefore we adjust it accordingly.
Yeah, I would argue that the slippery slope argument, they're separate debates.
Yeah.
The UK assisted dying bill right now that is going through Parliament does not provide provisions for people with mental illnesses to allow themselves to take their own lives, or children, or people who are more than 6 months terminally ill.
Yeah, if someone has 8 months left to live, they can't.
Yeah, exactly. So we should just debate this particular bill right now, and if that comes up in the future, if terminally ill children becomes an issue in the future, then we debate that separately. That's a separate and completely different debate, and it shouldn't speak to this debate. We shouldn't be thinking, well, we could have a situation where children are euthanized. Therefore, we can't have any legislation whatsoever. We can just keep the system as it is.
It's sort of a straw man, really.
Yeah, basically, yeah.
I just had the thought, though, that this is a good start. Now we're on the slippery slope argument.
Yeah.
But people who tend to seek this out, I've seen a lot of accounts from people with motor neuron disease that are progressive. And if your prognosis is 6 months, then I don't know. I couldn't even begin to know, but I would assume that at that stage, you've already reached a point that you wouldn't have wanted to reach.
I mean, I guess it just depends.
I mean, this is speculation and highly, subjective, but
yeah, it probably depends on the particular illness. Probably depends on the
exactly.
Condition. Some people have motor neuron disease and live for a really long time.
Yes.
People like Stephen Hawking, for example, had a certain degenerative disease, and he lived until like it was 60 or something. So it's all very subjective.
But the main argument for is that people should be allowed to make that decision for themselves.
Yeah, exactly. And the argument that people make is that it's not really assisted dying in the sense that you have an ordinary life person who is then going to die. It's someone who is going to die already, and it's not assisting them in being able to taking their life, really. It's just assisting them in choosing themselves how,
at what point,
when, and in what way they want to basically they want to end their life along a road that's inevitable, if that makes sense. On a road that's inevitable, you're going to reach the end at some point. This is basically a question of how fast do you want to go to get to that end point.
And this is what I mean when I say that people place too much emphasis on the positive act implication, because I'm actually still quite shocked by what that person said on the podcast you were listening to. That they said essentially, you can choose to stop eating and drinking.
Oh, yeah.
I thought, what a horrific thing to say.
Yeah, that was an interesting one. That was more looking at the morality. I'll link them all. I'll link all the podcasts in the description so you can have a little listen for yourself. But it was a very bizarre argument that person made. Yeah.
I personally wouldn't find that very persuasive, because I feel like the whole point that is being made is that you're supposed to be able to choose to die in dignity.
Yeah.
And if you are refusing food and water, which people do, and I don't think people would choose that over what is being offered here.
Yeah, and what do you make of then a different argument, which is the idea that people who are terminally ill are a greater strain on the NHS, on the state, 'cause of course they require more drugs, more treatment and stuff, and so there is an incentive for people who run on the NHS, who do all this kind of stuff, who are politicians. It's an incentive for them to allow us to die for these people because it's less of an economic burden. They're making money back, or they're saving money in doing so, and so that's the reason for why they're doing it, or that's a perverse incentive for allowing assisted dying. What do you think to that argument?
Well, I'd sort of prepared a response to this argument because I wrote it down in my notes. I called it NHS utilitarianism.
Yes.
And I would say that anti-labor people might use this as a very easy way to demonize this policy by saying that Labour want to cut corners and save money on a dying NHS by allowing people take their lives, essentially.
Yeah. It's like a voluntary resignation scheme in a business.
Yeah, exactly. And you pointed out a Daily Mail article that was laying it on thick in terms of the demonization and what
and how horrific the process is. You have to eat horrible sludge, and you have to eat 100 pills in order to actually allow yourself to die.
Yeah, which is typical Daily Mail behavior.
Yeah.
But essentially, you said something that is a very succinct way of putting it, and it is basically confusing the intent with a satellite outcome of a policy.
Yeah.
Now, I would hope that the publicly provided intent of this legislation is that they're being true to what they're saying in public, which is that they're hearing what advocates for this have been saying, which is that we need some kind of support in place, and it's time to respect the wishes of people and provide a framework for this.
Yeah.
I seriously doubt that the intention is that we want to save NHS money by letting people.
Well, it would firstly be conspiratorial to make that claim, because you have no evidence that is the actual intent, and people would be trying to think of that intent.
Also, we don't know if it's empirically true, because all of this framework requires doctors to be seen, and specific visits and high court decisions, which cost money.
I think the evidence come from places like Canada shows that actually it does save quite a lot of money.
Yeah.
Because like a doctor consultation, 2 doctor consultation, and a high court judge and a pill are probably a lot more than ventilation machines, dialysis machines, all the kinds of things that you need towards the end of your life. I think it's empirically true that it will save money.
Fair enough.
But I don't think it matters, because, like you said, the result and the intent are not necessarily the same thing.
Yeah.
So, for example, having a policy of allowing abortions to take place necessarily reduces the strain on the UK's adoption NHS education system by having less children around.
But we don't encourage people to have abortions because of that.
No, the intent of having an abortion policy is not because along the road you're saving a bit of money on education or whatever. The fact that this is just an additional, in my opinion, technically, and being quite blunt and quite harsh, this is an additional benefit that is not even necessarily associated with the intent. And everything that this bill thinks of, goes into, the fact it's a private member's bill, the fact that it's very, very heavily regulated, and it very much puts the person in question front and center in terms of who is to be considered and who is to be thought of in terms of their decision.
And I think that's really important, because when people resort to these sort of anti-utilitarian arguments, by saying, "Oh, well, you just want to save money by letting people kill themselves," is really and this is a problem that I have more broadly with the sort of debating around this, is that it doesn't center the person. It leaves the person as an afterthought, because a lot of these arguments undermine what people have been begging for decades.
Yeah.
And it's really heartbreaking, actually, to hear or read about accounts of people that have been alone, or that they haven't had their family with them, or they felt pressured into maybe taking their life sooner than they would have because they had to travel to do so. And it to resort to sort of talking past them, I think, is really upsetting.
I think as well that the people who make the anti-assisted dying bill, I mean, in fairness, I'm not particularly pro or against this bill. I'm pretty neutral on it, but I'm not convinced by the people who are arguing against this kind of legislation.
Yeah.
Especially one with such strict safeguards in place, and given the fact that this is something that's been liberalizing in the rest of Europe for a while. The people who are generally against this kind of legislation, or euthanasia more generally, probably also wouldn't support, let's say, a loved one who helps and assists a person in taking their life who is terminally ill. Would they necessarily support that person being prosecuted by the CPS doing so? I don't think they would. I don't think most people would. I think most people would say that's probably not a thing that the police and the Crown Prosecution Service should be involved in doing.
Well, yeah, because the whole point of prosecuting for a crime is that, well, part of the point is that they might do it again.
Yeah, or it's in the public interest or something. But then, if that's the case, then people aren't necessarily against euthanasia. They are against a system where euthanasia is lawful.
Yeah,
if that makes sense.
So
euthanasia, they like the idea of decriminalizing euthanasia, but they don't like the idea of
instituting it.
Yeah, exactly.
Which again kind of goes to what I was just saying, in that they recognize that it's a thing, but they don't want any kind of implication in it. They don't want anything to do with it, and they don't want their state to have legislation. They don't want their state to have anything to do with it either. They sort of want to bury their head in the sand in terms of recognizing that it is a need that people have been expressing.
Yeah. What do you make of the disability rights argument? The idea that disabled groups, because one of the podcasts I listened to, they made the point that 350 different disability rights organizations have come out against this particular bill, and that you should be assisting disabled people in life, not assisting them to die, and all that kind of stuff. And that sort of ties in a little bit to one of the arguments that the ECHR arguments, the Article 14 violation on the count of discrimination on the basis of an Article 2 discrimination, or an Article 8 discrimination. What do you make to those arguments? What's your thoughts there?
Honestly,
yes.
The point of saying we should be assisting people in life is absolutely true. They're advocating for a good thing, and it doesn't mean that we can't have both, right?
No.
And the point that you're making about it isn't necessarily a huge cost or burden to have this framework in place, means that we're not really taking away from the ability for people to be assisted in their lives, people who are they have ability needs, or they have care needs, but they aren't terminally ill. This is a different conversation, surely.
Yeah, I mean,
I would say that it's this conversation. I've said it a few times today, even that it encompasses some disability rights concerns, but it is not the be all end all. It's a Venn diagram, right? They cross over in some places, but I think that it's, like you said, a red herring.
I don't think this is even a disability rights argument, or even a disability rights issue personally. Obviously assisting in life is true. It's not really saying anything. Of course, people should be assisted in life.
Mm-hmm.
That's the whole point of the legislation. I can understand why this could be considered a disability argument or a disability rights issue if we are talking about some of the other systems. I feel like people have sort of subconsciously imported the Belgium system or the Luxembourg system or the Canada system into this bill where that isn't what the bill is saying.
Yeah.
So if we're talking about people being euthanized for mental illnesses, people being euthanized for non-terminal illnesses or non-terminal disabilities, or children with whatever conditions, then absolutely it becomes a disability rights issue because it becomes an issue about people who are disabled. But I don't know if anybody else agrees, but intuitively, I view a person who has a terminal illness as different to a person who is disabled.
Specifically, as well, the people who are defined within this bill of having 6 months prognosis.
I don't see because like you said, it can overlap. So something like a motor neuron disease, a degenerative disease, causes you to become disabled in the sense that you are unable to do basic tasks,
Yeah.
or all this
and
kind of
you need
stuff.
care.
You need care,
that kind of thing.
But the idea, for example, of somebody who has cancer, who is terminally ill, who has 6 months less to live, I don't see that as a disabled person. I see that as a person who is terminally ill,
Yeah.
not somebody who is necessarily do you know what I mean?
Yeah, they might develop physical disabilities as a result of that cancer, but then these are also separate issues.
Yeah.
And I think some of the concern comes with people who are being coerced, disabled people who might feel like they're being a burden, or they're being pressured by people around them who don't want to care for them anymore. That is a horrific situation, but I don't think that this bill would allow for that to happen, because it requires the person themselves to make the request and be assessed by the high court and everything. And you would hope that in kind of tinkering with this bill a bit more, I think it might need a little bit more in terms of that, that it would have a look at the people around them and see who has been a part of the sort of discussion around this person taking their lives.
Yeah, I think as well, like, so some people who make the argument that, well, this will cause a system where people are pressured, then people are sort of bullied or coerced into thinking, well, I might as well take my own life because I become a burden onto my family or whatever. That to me doesn't speak of somebody who is necessarily against euthanasia in sort of isolation of anything else. That speaks to me as somebody who is against being coerced into assisted suicide, obviously. But then you'd have to ask the question, well, what other safeguards do you think are necessary in this bill to remove the problem of coercion or being unable to, or pressure, or all these different kinds of things? Because you've got two doctors separate, you've got a high court judge, okay? Coercion is made a criminal offence in this bill. So how what else do you need? Do you need three doctors? Would three doctors make a difference?
I don't know. I don't think.
If we said, okay, let's have 5 different doctors over the course of a month, each individually assessing this person, and 2 high court judges, would the same people come out and say the same thing, or will it? Is there any standard that would satisfy some people who raise that argument?
I honestly don't think so, and I think that the main disability advocacy argument in that we should assist people in life really goes to looking at the other systems and frameworks for healthcare and support and that kind of thing as additional to and part of this legislation.
Yeah, I think
So-
the assisting in life argument people make because they're like, well, we should have a better palliative care system. We should have a better this, better that, and this, better the other. And that's all true.
We could do that as well.
We could do that as well. But this is about people who have got 6 months at least left to live.
Yeah.
This is about a person who will die in 6 months regardless of anything that happens.
Mhm.
Okay, roughly 6 months. Reasonably expected to die in 6 months. So it doesn't matter. According to this bill, it's for people who irrelevant. It doesn't matter how much money you pump into the NHS, how much money you pump into scientific research. At the time of this point, okay, they will be dead in the next 6 months.
Yeah.
Okay, so accepting that point, this bill allows you to be able to do that in a way that you choose you want to do, taking that sort of free will and having that control.
Choose the process in which your life ends,
Yeah.
essentially. So, see your family members, and then you are at home, and you're in a comfortable environment, etc., etc.
Yeah.
And personally, I'm quite positive towards. I mean, this bill seems fine to me, but in principle, I'm quite positive towards the idea.
Yeah.
I don't think that there's anything wrong with it.
Yeah, generally speaking, I would probably vote if I was an MP. I'd vote for the bill. My final question to you then is: will this bill pass? It's currently at the second reading. Will this bill actually pass? It's not up to us whether or not we would support this bill. Unfortunately, we're not dictators, so.
Well, yeah. Well, you don't think so.
I'm not sure. I didn't think so at first. I'm not sure though. No.
I'm a little bit optimistic, I think.
Yeah.
I wonder, because I feel like currently the sort of political will is shifting slightly.
I think since you told me that when Sir Keir Starmer was the DPP, and he made reforms to the law that seemed to allow it to be more accessible, and now Keir Starmer is the Prime Minister, holding quite a large majority in Parliament. This is a backbench bill, a private member's bill, that is still nevertheless introduced by a Labour MP.
Mm-hmm.
I think there might be the ability for it to pass. I think there might be legs in it, actually.
I think it might take a while, though.
Well, it's got till the 29th of November to get to the second reading. It depends. It all depends. There is another bill in the House of Lords, as I mentioned, but at the very least, this bill is the one that everyone is talking about. There seems to be quite a lot of backlash against it, but that's probably why I'm still on the fence. I'm literally 50-50 about whether or not it would pass at this point.
Well, this is one of those age-old ethical conundrums like abortion, and this goes full circle back to when we were talking about human rights, is the reason why the European Convention on Human Rights is silent, the European Court, is silent on it, is because it is quite a complex and nuanced issue.
Yeah.
And people will always fundamentally disagree with it on principle.
Yeah.
And they will always find different reasons why it's unacceptable. And there will always be backlash, much like with abortion.
Yeah.
Against any legislation with it.
And it just goes to show the kinds of things that, like, the sort of moral system is so skewed depending on different states. We talked about this as well, didn't we?
Skewed.
To say skewered.
Skewered.
It's so skewed when we talk about different states. So, in more liberal states, in more Scandinavian countries, and Central Europe, this is not really a bill that is that controversial.
No.
In the UK, this is a bill that's quite controversial. If we were to fly over to the United States, this would be a bill that would never, ever make it anywhere.
Yeah.
Except for maybe, like, California or New York. Like, could you imagine in Alabama an assisted dying bill? In the same way that abortion in the UK is not very uncontroversial. We've had an abortion act since, I believe, the 1960s. Bear in mind as well, in fact, the Abortion Act in the 1960s was also a private member's bill that started in the House of Commons.
1969, along with the death penalty.
Yes, the 1969. So
good year.
So anybody who's criticising this bill as being, oh, it's just a private member's bill, it's not going to get anywhere, or it shouldn't get anywhere, or anything like that. The Abortion Act was a private member's bill as well. It doesn't happen very often that private members' bills come past and have major significance, but it does sometimes happen. But yeah, like abortion in this country is uncontroversial, but in the US, obviously, it is a very, very controversial question.
Increased in controversy as well.
Yes, exactly. So I think that's good. Yeah, that's a good full circle that you've just mentioned. Yeah,
thank
bringing
you.
bringing it all around.
So, unless you have anything more to say, I think I've covered all my points.
No, basically, in our actual expert opinion, it probably wouldn't violate the ECHR.
No,
probably not, and it's seemingly, a pretty good idea. I don't think there's any. I honestly don't see much controversy in this bill.
It's very what's the word? Humble.
Yeah,
it's a humble bill.
Yeah,
it's not very bold. I mean, it is bold to try the topic again and see if it'll pass. Finally.
See if public support is on it, but I don't see this as a deeply controversial issue.
No.
The controversy when it comes to philosophy policy is when you start thinking about, okay, well, what about non-terminal illnesses, or what about mental illnesses, what about children and their rights to die and all this kind of stuff. That's where or the nature of capacity, but that's a broader question in law anyway. The Mental Capacity Act is obviously something that people will write articles on forever, just like the idea of coercion in the law. But these are sort of tangential to the central part of this legislation, which I don't think is controversial in the slightest.
Nope.
Okay, well, I hope everybody's enjoyed this episode. I hope everyone's learned from it. Comment down below what you think of the assisted dying bill.
And also, where are you from, and do you have any kind of legislation similar or that kind of thing?
Yeah, people who are not in the UK. Yeah.
What's it like in your country?
Yeah, exactly. People in Europe, let us know, actually. If you're in Belgium or in Luxembourg or in Canada, a country that has quite liberal and lackadaisical approaches to assisted dying, or at least compared to the UK, how is it
liberal?
More liberal, yeah. How is it perceived compared to the United Kingdom? Because it has been quite controversial. There's been quite a lot of people speaking out against it. The sort of news organisations, the machines of media have sort of got the wheels turning against the idea, generally speaking. I've seen, if you Google the assisted dying bill and you sort of look at the headlines of the first few news stories, they seem to be overwhelmingly negative in terms of how they view this. I wonder if that's an indictment on media in general, or maybe just a
British media,
or just a sort of a snapshot of the general public's perception of it, or something like that. It depends on who you ask, really. Yeah. So yeah, I hope everybody's enjoyed it. Like I said, comment down below what you think about it. Comment down below if you live in a country that has a more liberal view on assisted dying, and I'm sure that we'll update you if this does get passed through. We might keep doing another episode on it if you want.
This has been good.
If there's anything else you want us to talk about, let us know, and we will do other podcasts in the future, basically. So thank you very much.